Good morning, everyone. I hope you're all well out there. Today, we're talking about refunds, returns, and repairs. So, looking at your business's legal obligations when it comes to handling issues that you have with your customers being consumers. My name's Rob, or Robert Nay. I'm head of legal here at LegalVision. I'm going to be hosting today's webinar for you. My background is also I'm a commercial contracts lawyer, so day in, day out, I'm working on contracts with consumers and also businesses. For the purposes of today, we'll focus more on what the consumer's rights are from you as a business, but towards the end of the webinar, I can touch on if you're supplying to consumers and also businesses and what that means for your terms and conditions. Before we begin, just a bit of housekeeping to get through, and then I'll get started on the content of the webinar. First of all, you'll be receiving the recording and the slides in the email that you used to sign up for the webinar. So don't feel like you need to madly take notes during the webinar. You can always check that at a later stage and flick through the slides. I'd also encourage everyone to submit the questions in the Q&A box, and I'll try to get to as many of them in the second half of the webinar as possible. Already had a few submitted before the webinar started, so that's great. But yeah, feel free to send them through and I'll get to as many as possible. And then at the end of the webinar, I'd really love to encourage you to fill out a 30-second feedback survey after the webinar. You can also add any questions for me and the team in that feedback survey. One other thing I'd like to touch upon as well is by joining the webinar today, you're actually entitled to a complimentary consultation with my legal team here at LegalVision. So for the next 48 hours, you can essentially just fill in that survey form at the end, put in your details, and then what we'll do is we'll set up a consultation for you to have a half-an-hour chat with a member of our growth team and also one of our lawyers to talk in more depth about your business and the legal support we can provide. Perfect. In terms of today's agenda, first of all, what I'd like to start off by talking about is change of mind returns. So what I'm talking about here is the cooling off right that consumers have under UK laws. Then we'll move into sort of the more contentious aspects of the consumer law. So when consumers have entitlements to repairs, replacements, and refunds. In the second half, I'll talk about terms and conditions, so your contracts that you have with your consumers and what's important there to think about. And we'll also touch upon refunds and returns and whether you need a return and refunds policy. And then obviously throw it over to yourselves for the questions at the end. To start off with, I'm sure a lot of you would be aware of the 14-day cooling off period under the consumer laws in the UK. So in effect, when you're supplying any goods, services, or digital content, and I want to just touch quickly upon those concepts. So goods, that's pretty obvious when it's physical products. Services, that could be professional services. It could be supplying software as a service as well. And digital content. Digital content is in effect data. So that could be images, it could be videos, it could be blogs. Essentially, the consumer law has those three concepts, and there's different consumer rights that you owe to consumers, so non-business customers, with respect to whether you're supplying goods only, services only, digital content, or a mix of two or three of those. In effect, and to simplify it as far as possible, when someone signs up to purchase from you as a business, essentially they have 14 days to cancel the service because they've changed their mind. What's important to note here is they don't need to give a reason as to why they've changed their mind about engaging you. Essentially, they just have that right and they can cancel for any reason whatsoever. One thing to keep in mind here is when we're calculating that 14-day period, it actually does depend whether you're supplying goods or services as a business or both. For example, if you're supplying services, so if you're providing taxation services or other professional services to consumers, essentially at the point in time when the consumer signs up for your services, they have 14 days to change their mind and to cancel the contract. So that's fairly simple. If, however, you're supplying goods, it ultimately depends on how the goods are delivered. So if it is a one-off delivery of goods, that's nice and easy. The 14 days will commence from the date you actually deliver the goods to the consumer. If, however, you were supplying goods on a subscription basis, so say, for example, you had consumers who received makeup kits on a monthly basis, the right to cancel would effectively be from the first delivery. So in that scenario, it would be from the first monthly delivery of the goods. The third aspect with supply of goods is where there is a supply of one good, but it is split into different components. So if you think about a supply of something large like a piece of furniture, it might be the case that various components of the furniture are split over multiple days. What's important to note in that scenario is the 14 days to cancel, the cooling off period runs from the delivery of the last component. So that can be important if you're working in the construction space, or yeah, if you're delivering sort of high value, bulky goods, which are going to be split over numerous days in terms of delivery. In a goods context, so the supply of goods, once a consumer has said that they no longer want the goods, what they have to do is essentially send back the goods, and they typically have to pay for the costs of returning the goods. But sometimes businesses will sort of, out of generosity, say that they will cover those expenses, but they don't have to. And they will return the goods within 14 days. And then effectively, once you have received the goods or once you've received proof of return, then you facilitate that refund. It's quite important as well again, in a goods context, that the refund that you should be giving is the full value of the goods, but also any delivery costs that they paid in their order. So you don't have to necessarily refund the costs of the consumer returning the goods, but the actual delivery goods associated when they first obtain the goods from you need to be refunded. What I'd like to touch upon as well is it may seem simple that there's 14 days to cancel a contract, but in the regulations, there's actually a lot of carve-outs or exclusions as to when the cooling off right doesn't apply at all. So as you can see on this slide, there's some of the key examples here. I'll run through these at a very high level. First one being if there is the supply of goods or services and it doesn't cost any more than £42 and it's an off-premises contract. What I mean there is it's a contract for sale of goods or services which is not in store, not on the business's premises, and is not online. So a good example there is a fair. And one thing to step back a little bit with respect to the change of mind in general is that it applies to any contract that is not an in-store purchase. So typically online, but it could also be door-to-door sales, or it could be sales at a location which is not the business's premises. Some other examples there are perishable items. So food deliveries are not going to be subject to the right to change of mind. Customized or personalized goods. So if you supply t-shirts and they have personalized slogans on there for the consumer, that's not subject to the change of mind entitlement. Any software or sealed audio or visual that is opened after delivery. So if you supply video games and someone actually opens the video game and starts playing, then there's a carve out for that as well. One thing that I'd like to point out in terms of one of the key exclusions to the right here as well is with respect to services. So if you're supplying services, what's really important to note is that if a consumer is asking you to start the services within the 14-day period, what is really, really important is to make sure you've actually had an express request from the consumer for you to start supplying the service during the 14 days. And also for the consumer to acknowledge that they will lose their right to cancel the contract. And if the services have been performed during that 14-day period and then they cancel, essentially they have to pay you a pro rata amount of the price of the services to cover the services that were provided during that period. So if, for example, you provided half of the services in 7 days, they would essentially still have an obligation to pay you half of the value of the services, but only if you actually got their express consent to proceed with the services. When I get to talking about the terms and conditions, I'll touch upon that point because there's some things to think about when the terms and conditions are accepted by a consumer to make sure that they're actually giving you that express consent when you're providing services. A few other examples are urgent repairs or maintenance. So if, for example, you are an electrician or a plumber and you're getting called out to a home to fix a leak or something that is urgent and needs to be addressed right then and there, the consumer doesn't have a right to change their mind. And another good example is accommodation, transport of goods, vehicle rental, catering, or leisure services on specific dates or periods. So if you have a wedding, you're providing wedding catering services and the wedding is within the 14-day period, the consumer doesn't have that right. Some things to think about is once you've established whether a consumer has that right or doesn't have that right because they're subject to any of the exclusions, consumers may still have rights if, for example, the goods or services or digital content are defective, not fit for purpose, of a sub-quality standard. They may still have rights, and we'll talk about those in a few minutes. It's also important, as I've just run through with respect to those exclusions, to have a think about your business, have a think about exactly what you're supplying to consumers, and to see whether the right applies at all, or whether it applies in certain circumstances, and to make sure that that is clearly and properly set out in the terms and conditions that your consumers will see when they're engaging you. If, for example, you're supplying high value goods, so anything that is really complex, high value, difficult to potentially sell to other consumers, one thing you may want to think about is taking into account the 14-day period before you actually commence the production of those goods. I guess with respect to that, I mean, ultimately, they will still have the right once it is delivered. So, I mean, it's just something that you've got to factor in. But obviously, to the extent that any goods are bespoke or particularly tailored or personalized for a consumer, they don't have that right. So one way to think about it is this right should be for goods that can simply be returned to the shelf, so to speak, and sold on to another consumer. And as I touched upon just before, where you're supplying services, really, really important to ask for that express consent to commence the services and for the consumer to acknowledge that they will lose their right. So that's the cooling off period. That again is where we're talking about where a consumer has just decided for whatever reason that they don't want to go ahead with the goods. Now, what we'll talk about is where there's actually issues with the quality of the goods or services or digital content, because they don't meet the consumer's rights under the consumer law. I'm going to keep this quite high level ultimately consumers have a number of different rights, and there are different remedies or entitlements that they have if a business doesn't meet those rights. It is quite complicated and it depends on the circumstances. So if you're ever having an issue with a customer, really good to reach out to the team, have a chat with a lawyer, understand where you stand and where the consumer stands with respect to their statutory consumer law rights. Generally speaking, to simplify it in a supply of goods context, within the first 30 days of the supply, so ignoring the cooling off period of 14 days, consumers can reject any faulty goods for a full refund. After 30 days and up to 6 months, essentially what they have is a right to a repair or a replacement of faulty goods. So that gives you as a business an opportunity to fix the goods or to replace them. And if, for example, that doesn't satisfy the issue and they're still faulty, then there's a secondary entitlement that a consumer has during that period to either a refund or a price reduction. After 6 months and anywhere up to 6 years, which is the limitation period for contractual claims, consumers can either request a repair or a replacement. I think what's important here is during these periods, you might wonder who actually has the onus of demonstrating that a good is defective or faulty. Now, within the first 30 days, that onus is on the consumer, but then it flips during the 30 days to 6 months to the business, and the business needs to essentially demonstrate that the goods were not faulty when they were initially delivered. And then after the 6-month period, it then defaults back to the consumer having that onus and needing to prove a defect. Regarding digital content, so again, digital content is data, so videos, images, blogs, etc. Often digital content and typically is supplied alongside goods and or services. If the digital content itself is not satisfactory, it's not fit for a particular purpose that a consumer's alerted a business of, then the consumer has the right to a repair or a replacement. And again, if this doesn't sort of satisfy the issue, then they're entitled to a price reduction. There is also a right in the consumer law to compensation for damage. If, for example, the digital content, the data actually causes damage to a device that a consumer has. So if it causes issues to their computer, they may be entitled to compensation as well. Regarding services, a little bit more simple, I think. Essentially, there's a couple of key consumer rights with respect to services. So one of the key ones being that the services will be provided by the business with reasonable care and skill. Essentially, if that is not met, the consumer can ask for repeat performance, so for the services to be redone. And again, if that doesn't work, then they're entitled to a price reduction. The other sort of key consumer law right with respect to services is that the services will be completed within a reasonable time. If that is breached, then they're entitled to a price reduction. Some things to keep in mind with respect to repairs, replacements, and refunds is, as a business, you're entitled to ask for evidence of the defect or an opportunity to inspect. So allowing you to actually work out if the claim by a consumer has legs, whether it is valid or not. Internally, what's also really important is to keep really clear records of issues that you have with consumers and also any repairs or replacements that you've carried out or sent out to a consumer. And one thing I would also say as well is when you're dealing with consumers, it's a little bit different from dealing with businesses. Ultimately, the best course of action is to try to be consumer focused, to try to resolve issues commercially. And I guess the key risk there is that there always is a chance that a consumer can jump on Google or Trustpilot and post a negative review. And sometimes, even if they don't necessarily have a really strong claim, the impact of that negative review can do a lot more harm than actually sort of facilitating an outcome with that consumer. So a little bit different from when you're dealing with other businesses where you can hold your ground a little bit more. You should always just be aware that there is a chance that people can post things online and that could be more detrimental to your business. Excellent. So those are at a very high level, in a nutshell, the key consumer law rights with respect to refunds and repairs and replacements. What is really important with your terms and conditions is, first of all, that you have terms and conditions in place. Essentially, terms and conditions can be on your website. So they could be click wrap terms and conditions where when a consumer is signing up for your services, your software, or ordering goods off your website, they scroll through, they click accept. Or it could be a more traditional form of contract where you email across a Word or PDF contract. Either way, terms and conditions can help to limit your liability and to define your obligations as a business, but also the consumer's obligations. Often in the case of disputes, having really solid terms and conditions is your first line of defense. We often have people come here to us, businesses coming to us with issues with complaints from consumers, and their terms and conditions are non-existent or they're not great. And that just makes dealing with a dispute harder. It's always easier where you've got a really clear set of terms and conditions that establishes what each party is entitled to and what they're responsible for to facilitate an outcome in the event of a dispute. One thing as well is under the consumer law, where you're supplying to consumers, there are what we call information requirements. So it's as it sounds, certain information that needs to be in the terms and conditions to essentially alert a client or consumer as to what their entitlements are at law. If those information requirements are not met in your terms and conditions, you may not be able to enforce the contract against the consumer, which is obviously not ideal. Some other things to think about in the terms and conditions are dispute resolution, payment terms, so making sure that you actually have an entitlement to be paid, and if payment is not made, that you have some other entitlements as well. Here at LegalVision, with respect to drafting any contract, we are very adamant that contracts should be drafted in clear, plain language. You should avoid legal jargon as far as possible. And this is really, really important when you're dealing with consumers. Terms and conditions should be drafted so that any person out there, any mum or dad, should be able to pick up the terms and conditions and understand what they mean. They should be reasonably balanced and fair, and we want to avoid any unfair contract terms, and there's separate legislation covering unfair contract terms. They should also be accessible at the time, or ideally before, a customer makes a purchase, and they should be regularly updated, ideally once a year, to take into account any legal or regulatory changes. In those terms and conditions as well, covering what we've discussed today is it's really important to make sure you're being really clear on what the returns, refund entitlements are for the consumer and also the process. How do they go about reaching out to you if they have an issue or if they want a refund? One thing that I mentioned earlier with respect to the cooling off right, so this is the right to change their mind for any reason. And with respect to services, again, just to reiterate, there's that obligation to get a consumer to give express consent to you performing the services. One way that you could do that is if people are signing up through your website, you could actually have a further checkbox. So they click to accept the terms and conditions, but you could have a further checkbox that says, I consent to the services being provided during the 14-day cooling off period, and I acknowledge that I will lose that right and I'll have to pay for the services if I cancel during that period. So again, we can provide you with guidance as to what that language is, but a really nice and easy way of covering off that point where a consumer wants you to get started on the services straight away within that 14-day period. Now, the last sort of substantive topic I want to cover off here is returns of refund policies. So one of the questions I often get is, do I actually need one? The answer is strictly no, but they are a really good tool to sort of be transparent with your consumers and also other businesses you're supplying to so that they know exactly what their rights are and what they need to do to facilitate a return or a refund. These can either be built into your terms and conditions, or they could also be a separate policy. So it could be a separate link on your website. What's important as well is obviously we've talked about the statutory rights here, so the rights under the consumer law, but often businesses will go above and beyond what their legal obligations are. So for example, with ASOS or a number of other large retailers, they won't just offer a 14-day cooling off period, they might offer free returns for 30 or 60 days. So they're going above and beyond their legal obligations. And if you're doing that, what's important in any refund policy or returns policy is just to set out that this is above and beyond the statutory rights that a consumer has. And it also doesn't impact any rights that a consumer has at law. Some of the things that you'll see in a returns and refunds policy are, or maybe that an original receipt is required just to prove that the consumer paid for the goods and purchased them. That the goods are returned unused and unopened, setting deadlines for returns as well, saying that a consumer may be entitled to an exchange or a credit note instead of a refund. But really important on that point, if a consumer has an entitlement to a refund at law for the rights that we've been through there, for example, you can't then say that they are not entitled to a refund and they're only entitled to a credit note or an exchange. So just being really careful that in your communication, in the policies, and also when your sales or customer care team is working with consumers, that you're not making it out to a consumer that they don't have rights, which they actually do at law. A few examples of some things that are good to avoid is statements like no refunds given, goods can only be exchanged, which is what I was touching upon there, only credit notes against faulty goods, sold as seen, no refunds except where the goods are faulty. It's best to distinguish legal rights and anything additional that you're offering. And yeah, avoid any statements that could be interpreted by a consumer as restricting their legal rights. So that's sort of the key substantive part of today's webinar. Just wanted to touch on a few things before I get to some of your questions. And we've still got plenty of time for those questions, which is great. One of the first things I wanted to touch upon is LegalVision has a startup manual. So I know a number of you joining today are startup owners. We work with a heap of startup owners and SMEs as well. We've got a really good manual which gives you some insights as to the different areas of legal protection and also some commercial guidance that you should be thinking about when you're setting up your startup and in the early days of your startup. So once you get the slides after today's webinar, you can just scan the QR code and download that manual. I'd also like to just quickly touch upon our next webinar here at LegalVision. So it is Sweat Equity, helping your startup grow. So again, focus on startups and focus on the time and sweat and energy that startup owners put into the business while not necessarily being paid for it. So what you can do there in terms of issuing shares. So that's on Tuesday, the 29th of October, again at 11 a.m. And you can register on our website at the events page. Becoming a LegalVision member, this is something that I'd really encourage any startup and SME business owner. So essentially, LegalVision's membership is an unlimited legal membership to all of your business as usual legal needs. So in effect, you can pay a fixed monthly fee and you get access to the team of lawyers in my team across all of our practice areas. So that includes unlimited document drafting and reviews, and also on the paper negotiations as well. Unlimited legal advice consultations. So you can easily log in, book a call with our team via our platform called Prism. Unlimited UK trademark applications, really quick turnaround times as well. So 3 to 5 business days to draft any contract for you. And yeah, affordability and a really large team of expert lawyers who are experts in the practice area that they work in. So again, you'll receive a survey form at the end of the webinar. Just pop in your details there and we can get you set up for a complimentary legal health check with one of our lawyers, and use that as an opportunity to dive in a little bit deeper into your business, see the areas of legal support that you have currently, what areas are missing, and then get you a quote for our membership. Okay, perfect. So we'll move on now to the Q&A section. So there were a couple of questions submitted before the webinar, so I'll just have a look at these. And in the meantime, feel free to use the Q&A box and just submit your questions for me now. So one of the questions that I have here is, are there penalties for non-compliance? Really good question. So in respect of not complying with the consumer law, the CMA is essentially the key regulatory body that monitors consumer law compliance in the UK. They have powers to impose penalties on businesses, and that can be up to 10% of a business's turnover. Probably not going to happen in sort of the first case of something going wrong with a business, and maybe say for larger retailers, but really important to note that ultimately consumer law compliance for businesses is really important, and there are entitlements for the CMA to impose penalties. Yeah, the second one here is kind of a similar point about what do I do if there is a disagreement with a consumer, and what can a consumer do as well? So I guess with respect to dealing with consumers as a business, again, I think it's really important, as far as possible, to be consumer focused, to try to resolve the issue between you and the consumer as far as possible, to hear what they're saying, to understand what their grievance is, and trying to work out if you can come to a commercial outcome. It's also really important to get advice, ideally from a law firm, as to how you need to, what steps you need to do to actually address the consumer's complaint. Do they have a legal basis for their complaint? If yes, then you obviously just need to facilitate the repair, replacement, refund, resupply, whatever it may be. Or do they actually not have a right, but they seem like they're going to be a pain, and there is a really good chance of them making a complaint to an ombudsman or posting a negative review? Is it actually easier to just offer them a partial refund out of goodwill? Okay, so yeah, keep these questions coming in. The next one I've got is about what if I have business customers and also consumers. So yeah, really interesting point. When you're supplying goods or services to businesses and also consumers, The key thing to think about there is ultimately businesses have different rights to consumers. In respect of supplies to other businesses, it's a lot less regulated than the consumer law when we're talking about consumers, mums and dads purchasing things off you. With respect to your terms and conditions, you could definitely have the one set of terms and conditions that covers B2B and also B2C. Or if it's easier for you, for example, if you've got different pages on your website or whatnot, that allow sort of the sales funnel of consumers to come in at a different location to your business customers, you could definitely split them out as well. And with the business terms, you can be a little bit more onerous in terms of what's in those contracts, how you limit your liability. But what's really important is to get those contracts drafted bespoke to suit your business. And that's where we can provide a lot of value. A similar point there with respect to businesses as well is what rights do businesses have? Now, there are still some rights that other businesses have. So I touched upon it briefly, but unfair contract terms. In the UK, there's actually two sets of unfair contract terms legislation. So essentially saying that businesses can't put certain provisions in their terms and conditions which are not reasonable or unfair. Now, there's different legislation that applies to consumers as opposed to businesses. The tests are relatively similar, but there are distinctions. So one thing again is it's really important if you've got T's and C's in place at the moment is to have them reviewed by our team to make sure that not only from a consumer law perspective, but also when you're dealing with businesses, that they're reviewed from an unfair contracts terms perspective. So just see if we've got any other questions. Yeah, there's one other really interesting question here. So the question is, I supply internationally. What do I need to think about? So excellent question. Where you are supplying to people worldwide, in an ideal world, you would have your terms and conditions reviewed in each country that you operate in. That's not practical. There's very few companies that have the budget to be able to do that. What I would recommend there is, look, you're incorporated in the UK, presumably. So the best course of action is to have your terms and conditions reviewed from a UK perspective, if that's your core client base. Also, in terms of sort of the protections, the level of protection that we have in the UK or similar jurisdictions is probably going to be more favorable to a consumer than in a number of countries around the world. So focus on where your core client base is and where you're actually incorporated as a business, and then go from there. And if you're sort of venturing out into particular regions, it might be the case that the bigger you get, the more you want to consider a consumer's rights in other jurisdictions. But when you're starting out, just really important to focus on the UK. Excellent. So I'll just leave it open for a minute or so for anyone else to submit any other questions, which I can pick up. But as you're doing that, just a reminder that you can download the startup manual, so LegalVision startup manual, by using the QR code once you get this slide deck. You can also submit any questions off the back of the webinar to reply@legalvision.co.uk or by submitting the feedback form as well. Doesn't look like we've got any more questions, so hopefully I was able to answer some of your questions today on the webinar. Again, a reminder to book in your complimentary legal consultation with one of our lawyers. And the survey will pop up at the end of the webinar, so just complete it, really easy. Shouldn't take any longer than 30 seconds. Would love to hear your feedback and any further questions that you've got, even if there's questions that you haven't thought about now that pop into your head later in the day. So just a reminder, you've got 48 hours to redeem that offer. And yeah, really hoping to see as many of you as possible on those consultations. Perfect. Well, we'll leave it there. We've finished a little bit short, so I'll give you 5 minutes back in your day. But thank you so much for joining me. Again, my name's Rob. I'm head of legal here at LegalVision. Lovely seeing all of you virtually, and hopefully we'll speak to some of you soon. Thank you so much.